Fujiki v. Marinay, GR, number 196049, June 26, 2013. Opponent D. Justice Carpio. Facts. Petitioner Minoru Fujiki is a Japanese national who married respondent Maria Pascal Marinay in the Philippines on January 23, 2004. The marriage did not sit well with petitioner's parents. Thus, Fujiki could not bring his wife to Japan where he resides. Eventually, they lost contact with each other. In 2008, Marinay met another Japanese, Shinichi Makara. Without the first marriage being dissolved, Marinay and Makara were married on May 15, 2008 in Quezon City, Philippines. Makara brought Marinay to Japan. However, Marinay allegedly suffered physical abuse from Makara. She left Makara and started to contact Fujiki. Fujiki and Marinay met in Japan and they were able to re-establish their relationship. In 2010, Fujiki helped Marinay obtain a judgment from a family court in Japan which declared the marriage between Marinay and Makara void on the ground of bigamy. On January 14, 2011, Fujiki filed a petition in the RTC entitled, Judicial Recognition of Foreign Judgment, or Decree of Absolute Nullity of Marriage. RTC dismissed the petition for judicial recognition of foreign judgment, or Decree of Absolute Nullity of Marriage, based on improper venue and the lack of personality of petitioner Minoru Fujiki to file the petition. Issue 1 of 3. Whether the rule on declaration of absolute nullity of void marriages and annulment of voidable marriages or AM number 021110 SC is applicable. Held, no. Rule on declaration of absolute nullity of void marriages and annulment of voidable marriages does not apply in a petition to recognize a foreign judgment relating to the status of a marriage where one of the parties is a citizen of a foreign country. Moreover, in Giuliano Lave v. Republic, this court held that the rule in AM number 021110 SC that only the husband or wife can file a declaration of nullity or annulment of marriage does not apply if the reason behind the petition is bigamy. While the Philippines has no divorce law, the Japanese family court judgment is fully consistent with Philippine public policy, as bigamous marriages are declared void from the beginning under Article 35(4) of the Family Code. Bigamy is a crime under Article 349 of the Revised Penal Code. Thus, Fujiki can prove the existence of the Japanese family court judgment in accordance with Rule 132, Sections 24 and 25, in relation to Rule 39, Section 48b of the Rules of Court. Issue 2 of 3. Whether a husband or wife of a prior marriage can file a petition to recognize a foreign judgment nullifying the subsequent marriage between his or her spouse and a foreign citizen on the ground of bigamy. Held, yes. The recognition of the foreign divorce decree may be made in a Rule 108 proceeding itself, as the object of special proceedings is precisely to establish the status or right of a party or a particular fact. Rule 108, Section 1 of the Rules of Court states, Section 1, who may file petition? Any person interested in any act, event, order or decree concerning the civil status of persons which has been recorded in the civil register, may file a verified petition for the cancellation or correction of any entry relating thereto, with the regional trial court of the province where the corresponding civil registry is located. There is no doubt that the prior spouse has a personal and material interest in maintaining the integrity of the marriage he contracted and the property relations arising from it. Issue 3 of 3. Whether the regional trial court can recognize the foreign judgment in a proceeding for cancellation or correction of entries in the civil registry under Rule 108 of the Rules of Court. Held, yes. There is neither circumvention of the substantive and procedural safeguards of marriage under Philippine law, nor of the jurisdiction of family courts under R.A. number 8369. A recognition of a foreign judgment is not an action to nullify a marriage. It is an action for Philippine courts to recognize the effectivity of a foreign judgment, which presupposes a case which was already tried and decided under foreign law. In the recognition of foreign judgments, Philippine courts are incompetent to substitute their judgment on how a case was decided under foreign law. They cannot decide on the family rights and duties, or on the status, condition and legal capacity of the foreign citizen who is a party to the foreign judgment. Thus, Philippine courts are limited to the question of whether to extend the effect of a foreign judgment in the Philippines. In a foreign judgment relating to the status of a marriage involving a citizen of a foreign country, Philippine courts only decide whether to extend its effect to the Filipino party, under the rule of lex nationalis expressed in Article 15 of the Civil Code. For this purpose, Philippine courts will only determine, 1. Whether the foreign judgment is inconsistent with an overriding public policy in the Philippines, and, 2. Whether any alleging party is able to prove an extrinsic ground to repel the foreign judgment. That is want of jurisdiction, want of notice to the party, collusion, fraud, or clear mistake of law or fact. If there is neither inconsistency with public policy nor adequate proof to repel the judgment, Philippine courts should, by default, recognize the foreign judgment as part of the Comity of Nations. Decision: the petition was granted. The order and the resolution of the RTC are reversed and set aside. The RTC is ordered to reinstate the petition for further proceedings in accordance with this decision.